Hi, and thank you for joining us. This is Friends of Liberty Live, our third episode. And today I have Luiza McQueen and David Kahle joining us to discuss their situation with Juvenile Court. Last episode, we discussed some of the great things that have happened in Claremont County with public officials and the justice system. These two individuals, along with several other residents that have reached out to us, have had a different perspective on the juvenile court system in Claremont County. And they would like to share their stories today. So I'd first like to introduce Luiza McQueen, long-term resident of Claremont County. You're originally from where, Luiza?
South Africa.
South Africa. Serve on the Republican Party Central Committee.
I do,
for
how
5
long?
years. 5 years, all right. And David Kahle, how long have you been in Claremont County?
I've been in Claremont County for 12 years now.
Okay, and you currently serve on the Republican Party?
Correct.
Yep. And
Or I should correct that, 18 years almost.
18
now.
years?
Yeah.
Yep, okay.
And thank you for having me.
Yeah, anytime. So we brought them on the show because Friends of Liberty is, when we started our organization, we wanted to hear from everyone. So if we put something on the air and there's some discontentment, we're going to show the other side of it. And these two individuals would like to share their experiences, which is an opposing view of what we discussed on episode 2, which is that our justice system is very solid. Our county prosecutor is great. They have a different view, and I'd like to let them share that. So Luiza, I'd like you to start to share your experience with the Claremont County domestic court and juvenile court system. You've been through both. So I'm going to turn it over to you to go ahead and kind of give the viewers your perspective.
Okay. Well, I've obviously written down my points, so I'm just going to read them because I want to kind of go timeline so people kind of understand how we got to where we got to today. First of all, thanks, Bill, for having us here today. I really appreciate it. And I'm here to talk about the injustice done to my 3-year-old grandson by a magistrate in Claremont County in Juvenile Court, which is Magistrate Masterson. We have a magistrate who took a word of a guardian ad litem that was appointed by him. Her name is Catherine Montgomery. She orchestrated an inaccurate, incomplete, and slanderous reports about myself, and these reports angered Magistrate Masterson against me. Her recommendation, coming from someone who doesn't even have children, is that on the last weekend of every month, I'm to drive to East St. Louis to drop off my grandson by 1 o'clock on Friday, and not one single minute later, because Masterson has said that I would be held in contempt of court if it was a minute later. His grandfather drives from Arkansas, picks him up at 1 o'clock, and takes him back to Arkansas for him to spend Saturday and Sunday with his dad. Then Monday, he drives back to East St. Louis to be dropped off at 1 p.m., and I pick him up and bring him home to Ohio. All at my personal expense, because at this time, father has not been ordered to pay child support or pay anything on his own.
And how old is your grandson?
My grandson is 3 years old.
And he spends how much time a week, around how often?
So he spends exactly over 22 hours inside a car, strapped to a car seat, and it's approximately 1,400 miles in a space of 4 days.
And how often is that schedule?
We do this the last weekend of every month.
Every month?
Yes, and we have done it now 7 times.
That's crazy.
2 times occurred to begin with in May, and then it's been every single month since then. Father doesn't have to leave Arkansas. He basically waits for my grandson to be handed over on a silver platter. He doesn't have to take off work on Friday. He doesn't have to take off work on Monday. He just sits there. He doesn't even get in the car with grandfather and drive up to Arkansas, which he could spend an extra 10 hours with his son if that's exactly what he wanted to do. I was threatened and intimidated into agreeing into this absurd recommendation. No woman with children would agree to having a 3-year-old strapped to a car seat for over 22 hours and approximately 1,400 miles to go spend 2 days in Arkansas with his dad. Like I said, I have to take off work Friday. Monday we get up at 6 a.m. On the Monday we get ready. On the Friday we get ready and strap him to the car. to the car seat to take him to St. Louis. When I pick him up on Monday at 1 and drive back, we get home around 8 o'clock at night. This is a 4-day ordeal. It's not a weekend visit, it's a 4-day ordeal. All mothers know how difficult this is for a toddler. Anyone that has a child that age knows how difficult it is for a toddler to be strapped in a car for that amount of time. He cries all the way down, and the exchange is heart-wrenching. He holds on to me, he screams, he doesn't want to go. He has been put in a situation where it has stripped him of his innocence, and also we are dealing now with the traumas from these visits. He has nightmares. It's almost like now he knows when the visit is coming up, so he starts to get nightmares at night. He's been waking up, crying, saying, I don't want to go to my daddy's, because he knows the time is coming to the end of the month.
And we have an actual audio example of this, right?
We
that
do.
You've provided.
I do have an audio example of this.
Let's go ahead and listen to the example of the audio.
Baby, okay? It's just 2 days. 2 days. Gma's gonna be right here with you. I'm gonna be right here when you come back. All right? Right here. Okay, come on. Yeah, let's go. You need to go pee? No. Okay, I know you don't need to go pee. Papa says he loves you. Did you say bye to Papa? Bye, Papa.
Wow, that's heartbreaking to hear.
It is
that audio. I think that puts it into perspective of this child's. Isn't one of the main purposes of juvenile court and domestic court is for the interest and the best interest of the child? It doesn't sound like this is in the best interest of the child, from what I heard.
No, it's not. And like I said, now we are dealing with traumas. He was fully potty trained over the summer. He's now reverted back to diapers. When he comes back from visits with Dad, it takes us at least 2 weeks to get back into a routine, and then only to turn around and do it again. So as he's getting back into his comfort zone, he gets uprooted again so that this visit can take place.
Has anyone at any time made any mention of the mental health and stability of this child, of the impact that it's having?
Absolutely not. That's why the best interest of the child is not the best interest of the child.
That's awful.
So you ask how we got here. So I'm going to give you a quick timeline. So October 2018, my daughter was strangled by said father when she was 3 months pregnant with my grandson. Proposed adults to supervise visit is grandfather and step-grandmother. These are the same adults that witnessed the assault and also witnessed said father destroy personal documents of my daughters in a bonfire and didn't even attempt to stop the violent behavior. I spent then several months chasing after father who was on the run from the authorities to have him extradited from 2 states, Texas and Ohio. He was extradited back to Arkansas to stand trial. He got a total of 10 years and served 9 months. March of 2020, he was released in the middle of COVID on a 2-year parole, and he just walked parole this past May. May 2020 to July 2020, step-grandmother helped him violate his parole and drove him to Ohio, where he filed 5 domestic protection orders in a time frame of 45 days in our domestic protection court in attempt to abduct the child.
So he came to our court system here in Claremont County while he was on parole in Arkansas, violated his parole, and came to our court and filed for a temporary custody order?
A domestic protection order.
A domestic protection order against who?
My daughter.
Against your daughter?
Right.
The lady he assaulted?
Right.
Okay.
And the interesting part about the domestic courts, when you file the affidavits, for those people out there that don't know this, when you file the affidavits with the domestic court, you don't have to show proof that you're the father. So at the time, there was no paternity test established, so we didn't even know that he was the father. And he was not even named on the birth certificate. But yet, he was able to get not one, but 5 domestic protection orders. Every single one of them was dismissed. For those that don't understand the process, I'm going to explain it to you. You get issued, you file an affidavit, you testify under oath that information that you have given, that you are domestically related to that person, which he was not. He had been in prison, he had been released, he hadn't seen my daughter in over a year. My grandson at the time was 15 months old. When he came up here and he filed the affidavit and he swore to that, he goes in front of a magistrate. And a magistrate issues the domestic protection order based on the information that was given to him. Then they set the hearing for 10 days or 2 weeks out. So when the hearing comes, then they go in front of another magistrate, and the magistrate goes through everything and he presents his evidence, and the magistrate then decides, does this order stay in place or they're going to dismiss it? So that's how the process works. So he did this 5 times. The very last one, he was actually able to abduct my grandson. And he did this when we had already put in place in June of 2020 a civil stalking protection order against him. Because of him reoccurring coming up here, I went ahead and put that in place to protect myself, my grandson, and my daughter. Because he had made some comments on Facebook postings that he wished a certain South African Portuguese diva up in Ohio, referring to me, would get the COVID. So we went ahead and got the civil stalking protection order for 5 years. So at the time when he abducted my grandson in Goshen, Ohio, with the help of a Goshen police officer who escorted him to the house, and unfortunately I was not there and my daughter was not there. He was in the hands of my daughter's boyfriend, and my daughter's boyfriend was intimidated by a Goshen police officer. And when the Goshen police officer picked up the phone and called me and said, Miss McQueen, this is what's happening right now. And I said, absolutely not. I said, we have a civil stalking protection order in place that says he is not allowed anywhere near us.
So you advised them of the protection order you had?
Yes, I did.
And this is Goshen Police Department?
That's right. And the police officer said he didn't have time for this and put down the phone. We were on our way to the house, so you can imagine my state of mind and my daughter's, obviously, because we knew that said father, which at the time we didn't even know there was a father, was going to take him to Arkansas, because that's what he was trying to do. So we get to the house and Mason is gone, and we have to wait now because we got a copy of the frivolous domestic protection order that he filed, which he lied about. And now we have to wait for the 10-day period when we go to court for the hearing on this domestic protection order. Mark Kahle was our attorney at the time, and he went in with my daughter, and the protection order was dismissed. When they came out, my daughter was excited, obviously, and I asked Mark Kahle when we were going to get my grandson back, and unfortunately he didn't have an answer for me. He told me he didn't know. I wasn't sure what that meant, honestly. He said we needed to wait for the new order of the court to come out. This was a Thursday. The order came out. I received an email. Nothing was mentioned about the return of my grandson. You would have thought that there was something that should have been discussed in that hearing. Mm-hmm. This boy has been taken by this man that we don't even know if he is the father, and yet the magistrate, Katie McBride, and our attorney, Mark Kahle, didn't think that that was an important issue.
So you said, sorry to interrupt you, but you said Katie McBride. Was she related to Judge McBride?
Yes.
Okay. A daughter? Or?
Daughter, yes.
Okay, so that's Judge McBride's daughter.
Daughter, yes.
And Mark Kahle is the current county prosecutor.
That's
correct. Okay, just wanted to clear that up for
Yes.
the viewers. Okay,
That's
got
correct.
it. Sorry, go ahead.
So when I had reached out to several entities for help, including our sheriff, Steve Leahy, his best advice to me was to get my civil stalking protection order and go get my grandson down in Arkansas.
So essentially, your grandson had been kidnapped, and the powers that be in Claremont County were, you're on your own.
That's correct.
Nobody stepped up, not the sheriff's department, not the court, not the prosecutor's office.
Nobody did.
Wow.
Yes.
Okay.
August 2020, Magistrate Masterson granted me full custody of my grandson with my daughter's permission, as well as with the advice from my attorney, Mark Colvey, at the time. Now he's wanting to take that custody away from me, and he is trying to find said father unfit so that he can give my grandson to his dad. March of this year, I was insulted, threatened, intimidated, discriminated, and Magistrate Masterson was very prejudiced towards me, up and including having me surrender my passport without any reason. My counsel was not allowed to speak. I had to have the short end of a leash explained to me, and my counsel was told to rein me in. He made me apologize to the guardian ad litem for doing absolutely nothing. And after I apologized to her, he belittled me by stating that he didn't believe my apology was sincere. April 2022, we filed a recusal to have him removed from my case. And unfortunately, Judge Shriver denied it. And this is where we are right now. I have now, in the meantime, retained a new attorney, and we're hoping to continue moving forward with our case.
Wow, that's a really tough story to listen to, and I have a copy of the transcript that Ms. McQueen had produced to me, and there's some things that I would like to read. Just take a couple of minutes. I was actually shocked at Magistrate Masterson and the fact that Judge Shriver would allow this conduct in his court. Judge Shriver has been a long-term judge in this county, has served this county for many years, and the fact that a sitting judge would allow the conduct of a magistrate in our county to talk to anyone, no matter what the circumstances are, is extremely unprofessional and very disappointing, especially a judge that we recommend as our Republican Party and endorse. And it really bodes the question, should we be endorsing this judge any longer, allowing this kind of behavior to go on in a courtroom? It was explained to her, it's Ms. McQueen, you under here, and there are some mistakes in the transcription, I will go ahead and tell you. I'm reading it verbatim. You understand saying someone on a short leash, you understand that phrase? Ms. McQueen says, yes, I'm sorry, not familiar with it. The court, someone on a short leash basically means if circumstances dictate that he or she is the kind of down to their last chance or the last few chances. And the court, and Ms. McQueen said, I understand that. And the court responded, you're on no leash. Ms. McQueen said, okay. The court, you're zero leash, and I'm 100% serious. If you do not follow this court's order to the letter to the second, either Ms. Montgomery will file a dependency action, and this child will end up in Children's Services custody, or I'll just issue an order granting custody, probably to the father who you've tried so hard to remove from this picture. So do you understand that initial statement? So this magistrate threatened to pull this child from Ms. McQueen if she's a second late to meeting the father or a second late to anywhere. Everyone knows there's traffic, there could be all kinds of circumstances. Regardless, that's a very serious threat to make upon someone. The court, she said, yes, sir. The court, zero tolerance, zero. So if you deliver this child wherever at 5 p.m. and it's 5:01 and I get a wind that is 5:01, you will lose custody, period. End of story, and you can file all the objections you want because when I issue an order, the order is such that it is not subject to a stay. Now, you may get it overruled at some point, but by the time you get it overruled to your attorney, Mr. Andrews is going to be on his way back to Arkansas. You pull anything like you pulled in your little cronies, like you pulled with Miss Montgomery, this kid will be out of your custody faster than you can sneeze. Are we clear on that? Now, I have heard about the cronies, and the cronies in the situation were a couple of friends that were there for moral support. Did not intimidate this GA. This GA victimized herself to the court, and the magistrate took her word over Ms. McQueen's. The court, the first thing you're going to do is you're going to apologize to this young lady in the back. Ms. McQueen took the high road and apologized in open court. I'm sorry, Ms. Montgomery, for my actions. It won't happen again, I promise. The court, you better not. No, I promise, Ms. McQueen replied. You were a million miles out of bounds, the court says. And then she said, yes, I was, sir. So she humbled herself to just take the high road, agree with the court. That was still not enough for Magistrate Masterson. He kept going. These GLs worked their tails off to represent the best interests of these children in horrible cases. Horrible cases. Sometimes they are only the only person standing up for the rights of these kids. Based on the audio that I heard, that kid's rights is not being met. So this is just nothing but a bunch of nonsense coming from the court. And you take it upon yourself to threaten and intimidate one of them. There is no other way to look at it. Miss McQueen, can I say something? The court replies to her, no, you cannot say a damn word, verbatim. Miss McQueen, I just want to say, Miss Katie, and the court then says, go ahead. I really sincerely apologize. It wasn't my intention. My emotions got the better of me. The court, I don't believe a word of that, Miss McQueen, based on the history of this case. I don't believe, and I hope your apology is sincere, but based on the history of this case, I don't believe a word of your statement. And that was my intention. It was not my plan. Don't believe a word of it. So in addition to the risk of losing custody of this child, if there's ongoing issues you are causing to protect Miss Montgomery, I will appoint an attorney for her, and you will pay the entire bill. Are you clear? And it just keeps going. I mean, we don't have enough time to go through the whole thing, but the end result of this is the court requiring her to give her passport to the court. And you read this, and I got to say, I was very discouraged reading this, that this is happening in Judge Shriver's court. And I hope that if Judge Shriver watches this, that he hears me loud and clear. Any other re-elections I will be against until this kind of stuff is gone. I understand that Judge Shriver's timing out, but there are other court positions being open. And I have a long-term respect for Judge Shriver, and even if this is a one-off case, it should never happen in a court. And a judge should reprimand a magistrate for conducting what I would feel is very unprofessional conduct in their court. With that being said, we're going to move on to our other guest, David Kahle, who also has had a very similar circumstance in juvenile court. So with that being said, David, I'm going to turn this over to you so you can tell your story.
Okay, again, first I want to thank you for allowing me to have this time. And I want to make this officially clear. I'm declaring myself a whistleblower as of right now. I went to juvenile court on May the 3rd and filed for custody of my autistic son because I was at the very end of what I could possibly do trying to convince his mother to stop displaying improper sexual behavior in his presence. He was at the point where it had been going on for more than a year, but she admitted under oath that, in her opinion, it had been going on for the last year. So just taking her own statement, there's at least a year she's agreed to that it was going on. And at that time, he was starting to self-gratify. And so I felt like I needed to put a stop to it. So I went to the courts for help. And
Just to be clear, what was the age, David,
at the time, it was 2016, so he was 11 years old.
Okay.
So she was talking about his 10th, 11th year, and at that time he was in what I would call pre-puberty.
Gotcha, right. The prepubescent
Right.
child, right.
So
Gotcha.
there were some things that were starting to happen to his body that he was discovering.
Of course.
At this time, I think the best thing to do is just play the tapes that I gave to the GAL and to the court, and then we'll continue with it from there.
So there's a couple of audios that go along with this case, and to just give some insight here, we'll go through the documentation, but these audios that we're going to share may be a little disturbing to hear, so just view with caution, but it's an admittance of this, what
Guilt.
Mr. Kahle is guilt of exposing this child to an opposite sex of the mother. So if we could go ahead and play the audio.
Mommy, is he in there with you while you're bathing again?
Yeah. Buddy, I picked it up and shut it.
Did you just get naked and dress in front of our son again?
Yes, I
And you call this the reason why we fight? Because of your bad judgment. When are you going to stop getting undressed in the same room with him?
He's sleeping, and I watched him the whole time.
It doesn't matter. It's the principle of it. He's 11 years old, and he wakes up all the time. And if you keep taking these chances and letting him sleep in your bed and then going upstairs and getting undressed in front of him, you're going to stimulate him, and he's not going to be able to
He's asleep, and I watched him the whole damn time just because I knew you were watching me. What do you want me to do? Go in his room? Fine.
No, I want you to put him in his bed at night like we've talked about. He's 11.
I put him in his bed. He came back in this morning.
And then you put him back in again, and then you put him back in, and then eventually he stops. We had him broke. He was in his own bed overnight for a long period of time.
Fine, I'll do that. Just so I don't have to hear you.
Wow, those audios, man, she flat out admits to it.
Yeah.
So you had provided me some information here, and just reading through this, this is Judge Shriver on your case as well?
Yes.
So this is Judge Shriver again.
Now, first, you really need to explain to everyone, in this process, a GAL was assigned.
Okay, so you had a guardian ad litem.
The GAL got those tapes.
Okay.
I gave those tapes and interviewed with the GAL, and so he was fully aware of those tapes. And in his report that is now buried in the archives of the court, because they won't allow his report to come outside of the courthouse, he addressed the issue, and in his report he said that the accusations were true.
And is this the report from the guardian ad litem here? Is
No,
this the same?
so what you're seeing here is after that report came out, the parties were asked, will you sit down and come up with an agreement? And faced with this GAL's report, the attorneys got together and we came up with a parenting agreement. So we went into the juvenile court on, let's see, it was,
The February 14th?
no, that's the appeal. It was December, I think it's at the top of this.
October
No,
25th of
it's the top
17?
Where's that? The trial was done on December, I think, 16th.
Okay.
It was in front of Magistrate Masterson.
So you had an interaction with Masterson as well.
Oh, yes.
Okay.
And my interaction was completely different than what she did, but yet along the same lines of trickery. I was misled by Magistrate Masterson because we went in after she had been given the report by the GAL and after all this had come out, and we sat down and we said, okay, what can we come up with an agreement on it? So we had an agreement. We went through in the first 20 pages here of this report that you were talking about, this transcript, is basically the attorneys going through on the record and saying, okay, they agree to this, they agree to this, they agree to this. Then we came in and they asked both the parties, okay, you just heard what was said. Do you agree that that was the truth? Do you agree with this document? Do you agree that you're going to go by the shared parenting agreement, et cetera? We agreed to that. There were only two issues that needed to be argued because she was objecting to an overnight time with me on Thursday and an overnight time with me on Saturday that the GAL had recommended. Now, in his schedule for custody, he basically took the schedule that would typically be the mom's schedule and afforded it to me because I had been the caregiver all the time. And it's in his report or in his testimony, which was part of that as well too. Page 94. Okay, so during that time period, the primary care provider was Mr. Kahle. The GAL's reply was yes.
Okay.
And then also at the end, so we don't have to go back, he was asked, do you still believe that your schedule is in the best interest of Parker? His reply was, I do, as you can see.
Yep.
So everything was put on the record and both parties walked in thinking, okay, we've come up with an agreement. We're going to end this today. We were even, the attorney for me was the one who was instructed by the judge to actually right up, and I believe it's somewhere around page 20 where he instructs them. All right, so what will probably happen at the end of this process, Mr. Since the plan is your plan, what technically is going to happen is these contested matters, obviously I'll issue a decision regarding those and instruct you. I think I'll instruct you to make the changes according to the decision to the shared parenting plan. So the only thing that we were going to be testifying to, that we did testify to, was arguments about whether or not he should be overnight with me on Thursday night and overnight with me on Saturday. We walked out of that court thinking this was all said and done. When we got the decision, though, from Magistrate Masterson in January, he completely went against what the GAL had recommended, knowing that the GAL was no longer going to be on the case because the GAL had been promoted to a magistrate himself.
Okay.
There was no way he could go back in any consequence or future cases and say, wait a minute, he didn't do what I recommended. And I heard you say one of the things out of Masterson was, well, my GALs did this and I take very seriously. Well, in my case, he didn't take it seriously at all. As a matter of fact, he said, he's just a source. I don't have to listen to what he says.
So you had a different experience. I want to go back to the undressing in front of the child. Were charges brought up, indecency, anything?
I tried to do everything I could to get them to pay attention to this, and the court ignored it. As a matter of fact, one of the rules that they threw on me, and you would think they would be thinking about the best interest of my son, since it wasn't testified in front of Masterson, and we didn't testify and play those tapes because we had an agreement and it had been given to the GAL when the GAL had done his investigation, so it was part of that. When Masterson made his decision, we tried to go back in our appeal and bring the subject back up, and we were told you didn't address it when you were in the trial, so you can't bring it up now. As a matter of fact, you have a statement that...
Yeah, I'd like to read this. So you got the trial was part one, right? This
Right.
is the trial. And then number two was here, the magistrate's decision. This is
our
the
appeal,
objection.
or
So
objection.
you filed an objection to that because this wasn't brought up. Your objection says the magistrate's decision failed to consider serious issues pertaining to the failure of mother making appropriate choices in front of said child given his age. Specifically, the magistrate failed to address the serious issue of mother allowing said child to see her bathe and allowing him to sit in the bathroom and stare at her while she bathes. The GAL recognized mother's careless conduct in allowing said child to see her in the bathroom and while she changed clothes, as well as taking said child into the women's restroom, and there are less invasive options available. The GAL made the recommendations on this issue that were included in his report that were ignored by the Magistrate Masterson. Ignoring this issue is not in said child's best interest. Okay, so anytime you file an objection to a magistrate, it does go to the judge. So this is how Judge Schreiber responded to this objection. The objection, and we've got it highlighted here, other than the father's affidavit filed on May 3rd of 2016, the only mention of this concern is presented in the GLL's report, and it is based upon hearsay from the father. Well, we just played 2 audio recordings earlier in the show. It's not hearsay, that's factual evidence that was given to the court, and the court buried the evidence and ignored the GAL's statement, but over here, the GAL is God, and over here, the GAL is insignificant. So we have inconsistencies in this magistrate and completely two different scenarios, and how this magistrate operates court operations. A big problem. And then for a Judge Schreiber, to sit here and say, that this is hearsay when there's audio recordings, again, I fail to see how the judges are operating in the best interest of our county. It's very upsetting to read this information, hear these audios, and know that we, as a party, stood behind this judge to run over domestic court.
Can I say something to that?
I'm sorry,
So
juvenile court.
In our case, the strangulation part about our case has just been swept under the rug.
Right, another criminal act
Which,
that was...
given Gabby Petito that was strangled, to death by her boyfriend, strangulation in our case is not seen as a big issue.
Right. And not to take away from you, David, so I'll let you continue. I want to come back to that at the end, but Anything else on
Well,
your story?
Yeah, when you asked me to come in, you did tell me that we were going to be limited on time. So I wanted to highlight this. This is an example. My case has been going on for 7 years. There is a lot more that's
7 years in the
and-
court system?
7 years, and to this date, with the current ruling, there is still not a shared parenting order in place.
Isn't that the purpose of juvenile court, is to come up with a functioning plan for the child?
That is my understanding.
7 years.
7 years and north of $160,000.
That's how much you spent?
That's how much I've spent.
$160,000 in legal fees?
Yes.
Wow.
I personally think that that's child abuse, because by maintaining us caregivers in the juvenile court and having us pay so much money in legal fees, it's financially putting us in a situation where it takes away from the child.
And so we're dealing with domestic court and juvenile court. The two judges over these courts, you have Marilyn Brick over
Marilyn Burke.
Marilyn Burke over
Domestic
domestic
court.
court, and Judge Shriver
Over juvenile.
over juvenile. It just sounds like you guys have been through the ringer on this, and
Well, as I said, I used this as an example, but I want to highlight a few other
Yes,
things
go ahead.
that happened along the way. When I first filed on May 3rd, a few hours after I got home, my ex was waiting for me at the door, and she was aware that I had filed for custody. Process had not even been done with the paperwork. The stamps weren't even on it, yet someone let the cat out of the bag, and she was aware that I'd filed for
and this was
custody.
in juvenile, not domestic
This
court.
was in juvenile.
And so you have
I
a-
can only assume that it came from one place, because I did not deal with the judges at that point. I did not deal with the magistrates. I only dealt with the clerk's office.
So somebody in the clerk's office.
Someone, I believe, leaked this information. That caused a physical fight between the two of us. She initiated that fight. In that fight, I believe I was assaulted. That ended up being another issue in another court.
Was she charged with domestic violence?
She was. She was charged by the state. I was a witness.
Gotcha.
Ultimately, she got off. But there's a whole nother story that goes with that.
But did she plea down or
No.
like dismissed?
A trial was held. Before the trial was held, I was pulled into a conference room by a attorney, a prosecutor, and he told me, he said, I know there was two parts to this. One where she pushed you and a door was slammed on you, and another part where she bull rushed you 7 times and tried to force you across the room and go down the stairs, but I'm only going to prosecute her on the door slam. Trust me, I know what I'm doing. So we're not going to talk about the second half of what she did. We're only going to talk about the first half. The other statement he made was the police officer who processed this and did this investigation is in Columbus, I believe. He said, doing something with the force. She can't be here today. So we don't have the police officer. I said, well, that's the timeline. That's going to corroborate the timeline. Trust me, I know what I'm doing. I don't need her.
This is the prosecutor.
This is a prosecutor telling me that. And as it turned out, I felt like I was just thrown under the bus.
What year was this?
This was 2016 still.
So this was Vince Ferris was the prosecutor.
So
at the time.
at the end, the judge made the statement that there's no doubt in my mind that you got a door slammed on your foot, but the problem is I can't tell if it was intentional or accidental. Well, in my mind, if the entire incident would have been viewed or presented to the judge, the second part of it, the 7 bull rushes, would have made it a little
Were
bit
you given a
stronger of
victim's
case.
advocate?
No. Another thing that she said was, oh yeah, I've got bruises all over myself, and almost tried to make it seem like I was the one who bruised her when those bruises were self-inflicted from running into me like this and bull rushing me. She ended up getting out of it, but that's a whole nother story in
Wow.
itself. I wanted to highlight that. Another thing I caught, ex parte hearings. Judge Shriver recused himself, so another judge was assigned to the case. And on that first day, I caught the attorney for my ex, the clerk of courts, and the newly assigned judge in the courtroom by themselves with my attorney still in his car, driving to the courthouse, having a discussion about our case.
Wow.
And they tried to play it off. The clerk came out and said, I assure you, we weren't talking about your case. Yet different facts came out in affidavits later that made it look like I was telling the truth. Nobody wanted to take that seriously. The Supreme Court Disciplinary Council pretty much said, well, we trust all of you as credible witnesses, so we're not going to take this investigation any further. When I was assaulted by her, I took it to domestic court. A magistrate removed her from the home, gave me my son. The next day she went in and saw the magistrate that we were assigned to hear from in 10 days from there. And he asked her, has he ever raised a hand to you? Her answer was no. He asked her, he said, has he ever made a threat against a member of your family or you? And she said no. He said, oh, well, but you did say that he's threatened you in the past. And she said, oh, yeah. And he said, well, that's good enough for me. I'm going to issue an order that says my order supersedes the magistrate who gave him an order against you yesterday, and we're going to take away the house and make him leave. We're going to give you back your son, and you're going to be the one.
You know the name of the magistrate that did this?
Magistrate Finney.
Magistrate Finney.
Yeah. I filed a claim against him because in listening to the audio from that hearing, he also started off the first 6 minutes by interviewing her on all the questions that the magistrate had interviewed
which they were
me
supposed to wait.
the day before. He was supposed to wait for that for 10 days. And what he did was he considered all that information in his decision, which basically took away my rights to a fair and honest trial.
Right.
And what he did, it's not superseding. A magistrate cannot supersede another magistrate. What he did was he usurped the other magistrate's decision, and that is not something that a magistrate of equal power can do. All he could have done that day legitimately was issue a matching order, which he didn't do. He superseded, as he said,
But
or
again, this is
usurped.
juvenile, not domestic.
This was in domestic court.
This is
So I've had
domestic.
contact
Okay,
with
just making
both
sure.
courts that have affected this.
And when
whole
was
thing.
this?
That was,
What year?
I filed, it's 2016. I filed on
So
May
all
the
of this
3rd,
was-
2016. The assault happened that night, so I went and saw my magistrate
This
on
would
May
have
the
been under
4th.
Rodenberg's
The next
watch.
day she went in on May the 5th, and that's when I was removed from
So
my home.
that's not Maryland
So,
Burke.
My
that's
point about
Rodenberg.
this, and I'm mentioning these few other things, there's more than just what I talked about with the nudity issue going on.
Right.
That's the focus that I don't want everybody to lose fact on. I've been advocating for my son because he can't speak. I have to be his voice, and I will not be stopped until someone pays attention to what was done and he gets the justice that he deserves for what was done back in 2015, 2016.
Has anybody from the county special needs, we have different departments and we offer different services for special needs families. Has anybody helped you in any of these other departments?
No, and truthfully, I feel the reason is because I'm a male. If this was done the opposite way, and I would have been caught in her position, I don't think it would have gotten past the first day.
I can guarantee you, if it was a female, if you had a daughter and you were a male undressing yourself, absolutely.
This standard thing and this double standard
Yeah.
things, it needs to come to an end with this court system.
And unfortunately, we live in a conservative red county, but we see a very liberal mindset in certain areas. These stories have definitely opened my eyes to a lot of issues in these two courts that need to be addressed. And I really appreciate you guys coming out here. I mean, it takes a lot to stand up and speak out and be whistleblowers to issues going on in the counties. I mean, we need more people to do that, because more people, the more people that come forward, the more we have. We're going to go, and I guess for me, I have a couple of questions to really end up here on, and it's for both of you. If you could just summarize it in a real brief statement, how do you feel that Claremont County courts have treated you and your child, Luiza?
I think it's been very discriminating and prejudiced towards me. And, David was talking about being a male. I'm talking about being, I think, Masterson, sees me as a foreigner and sees me as a woman. and he used the fact of taking away my passport as a form of bullying me and in controlling me, because at no given point in time did he ever ask if I had a passport, or even my grandson had a passport. So what was I going to do? Take off and leave my grandson behind? So that was showing that he used his power to manipulate, to intimidate me. And I feel like this is not about me, this is about my grandson. And my grandson has been robbed of his due process in this juvenile court because this magistrate, together with the guardian ad litem, Catherine Montgomery, have taken upon themselves to control and intimidate me into agreeing into something that it's ridiculous. No mother or grandmother would agree to something like this.
Right.
So they haven't protected, and I want them to be held accountable from the domestic court to the common pleas court to the juvenile court, to be held accountable for the way this case started, and it is where it is today. The fact that Judge Marilyn Burke won't unseal the records for us to see that he lied to the court, that alone would be a felony charge. She won't allow that. That's an issue. When there's no transparency, to me, I feel like someone is hiding something. To the common pleas court, when we put a civil stock in protection order in place, and they didn't back me up on it. When he came here and he violated it, they didn't back me up. You know, the sheriff's department didn't back us up on the abduction. And now in the juvenile court, they have taken away my grandson's rights. They violated his innocence. This is about my grandson, my 3-year-old grandson. You know, David's son can't speak, but my 3-year-old can't speak either. I'm an advocate for my grandson first, and then for my daughter.
Okay. David?
I feel like I've been gender biased this entire time.
Almost like we need a male's lib.
Yeah. Yeah. I mean, it's that simple.
I hear this in domestic violence cases for men versus women. It's constant in this county.
And what they don't know, because this is just one case in front of them, my history, back in 1985, I was given custody of my 2 daughters. They were 1-year-old and 2-year-old at that time, and I raised them as a single father. So this is not something that I'm not used to. My entire life has been in the care of children. This is the first child that I've had that's a special needs child, which requires a little bit more, but I'm an experienced caregiver. I would put my skills up against a woman, no offense, but I would put my skills up against a woman at any time. I think I'm very competent at raising children and nurturing children. And they don't take me seriously. And they need to take me seriously.
I agree. I think sometimes there is a bias against men being single dads. Women seem to get a little more sympathy, and we see it time and time again. The other thing I wanted to ask is, you know, when we're talking about inconsistencies in the court system, and you guys you share magistrates, judges, completely different scenarios and circumstances. But I do see some commonalities and some mistakes and things that are made. You know, do you feel like the child's best interest has been served in these cases?
David, do you want to explain the meaning of in the best interest of the child?
I've talked on this quite a bit. Magistrates and judges like to throw that term out. Legally, there is nothing under Ohio law that defines what the best interest of the child is. So when that term's thrown out, a magistrate or a judge in Cuyahoga County can have a separate opinion on a magistrate and a judge in Claremont County on the same subject, but they're both the best interest of the child. That term has no clarity, and I don't like that term.
Almost like we need to get with our state legislators to talk about putting
And define it.
And define it, especially if they're going to use it so loosely in their everyday language. It's in their decisions that it's used all the time. It's in their language in the courtrooms, but there is no definition of what that term means under Ohio law.
I mean, it's not in the best interest of a child to put a 3-year-old in a car seat for over 22 hours.
We have a couple of minutes left, and we're going to run short on time, but real quick, just yes or no, do you believe both parents should be in the child's life?
Yes, I have no problem. I mean, I have always said that the father should be in the child's life, but it needs to be phased in. There are certain things that he needs to do, a parenting class, therapy, Alcohol Anonymous, and that has not even been considered.
Right.
I mean, when he was in prison, he said he started a parenting class, but then didn't complete it because of COVID. He's been out now for 2.5 years and he still hasn't completed.
David?
Yes, I've always advocated
Wow.
that the best interest of the child is both parents.
See,
And-
I think that speaks volumes that you guys, even throughout all the negative, you still believe that the other parent would eventually best serve the
Absolutely.
child's interest.
It makes them more rounded adult when they grow up to have the two parents in their life and families in their life. I mean, this family, I continuously email them and let them know what the needs are of Mason, and I have absolutely no response from them. So that shows that that side of the family has absolutely no intention of having communication with this side.
Right. We have about 30 seconds. David, do you have a final statement?
Yes, I do. One of the reasons that I came on here, it's time to make people aware that there are problems within the juvenile and domestic courts and the law that need to be addressed and changed. To my research, a lot of these laws are still on the books since the late 70s. And now here we are in 2022, 23. Viewers, please get involved. There are several groups out there. I'm a member of Ohio Family Rights. Find a group like that and get involved. It's time to change these laws. The last thing, I'd like to look at you, Judge Shriver, in the eye. One of the issues that I'm having right now pertains to you looking me in the eye on October the 25th, 2017, and telling me that in my argument that I did not get any time with my son on weekends, you were going to give me the local rule 23.1 in Claremont County. You man to man looked me in the eye, and I'm telling you right now, what's happened in the last 3 years is the judge that's now on the bench is trying to usurp that. And you know I went through a trial. You found me not guilty of violating this November 17th shared parenting plan. It's time for you to step up and tell the truth and not be silent because you have taken yourself down off of this case. Your silence is hurting things and hurting my son more than anything, and it's in his best interest at this point for you to tell the truth.
Well, thank you both for being on. Our email address is FOLUunited@gmail.com. That's F as in Frank, O-L United@gmail.com. If you have any emails, thoughts, stories that you'd like to present on the show, please feel free to email us. Thank you for joining us today, and thank you to both of you.
Thank you.
Thank you.
Yeah.
We appreciate it.
All right,
Thank you.
everyone stay safe and have a great rest of your day.